What's good and what's happening, writers? My name is Vilimile Kumete. I am, of course, the creator, producer, and host of this brand new baby, the Nkantolo podcast. Now, a huge thank you to those of you who watched episode 1 and welcome to episode 2. Now, for those who may not know or understand, Nkantolo is a Swati or Nguni word for court of law. So if you're wondering what we'll be covering during season 1 of this pod, here you go. The apex court in Eswatini is the Supreme Court which has powers to decide matters brought to it on appeal or review from lower courts and tribunals. In season 1 of the Nkantolo podcast, we then take a look at the most recent judgments delivered specifically in that court. We then summarize and bring those judgments to you, our cherished viewers and listeners, so that you can be informed about the latest developments in decided cases in Eswatini's apex court. Now, after all, you and I are writers, traveling together to uncover the latest in our case law. So let's ride on the wheels of justice right now, nice and steady, and find out what happened or what transpired in the case of Masuku versus Masuku. So if you would like to get access to the text version of this judgment, you can do so by visiting eswatinili.org. That is eswatinili.org, where it is freely and easily accessible. Now, this case was heard by the learned appeal justices S.B. Maphalala, S.K.J. Matsebula, and N.J. Hlophe. This was on the 24th of November 2022. Their written judgment was handed down on the 7th of February 2023. The judgment records counsel for the appellant as Advocate L.M. Mazia and Advocate G. Shakwane as counsel for the respondent. So here's a fair warning. The facts of this case are a little bit complex, the relief sought is a little bit strange, and a judge of the High Court was cited as a party to the proceedings between the parties. So buckle up as we ride. It will be quite the experience. So we begin with a summary of the facts. This case had to do with the estate of a man who died and left behind a considerably large estate worth multiple millions of the lilangeni. Now, lilangeni is the Eswatini currency, which is equivalent to the South African rand. Now, this Mr. Masuku becomes deceased in the year 2001. He is survived by his wife and his 8 children, and then one of his sons becomes the executor of the estate. But then this role is later taken over by Mr. Masuku's wife. Mr. Masuku's wife advances in her years, and so she appoints one of her other sons to act on her behalf. So she signs a power of attorney giving this son authority to act on her behalf in all matters concerning her executorship over the estate. Now, this son is instrumental in much of the litigation involving the family. So, just like the judgment does, let's call him T. A number of cases involving the family are then instituted after the father's death. The first is a peace-binding matter between the mother and 3 of her children. She complains of them abusing her. She gets an order in her favor, but then she later abandons it in order for their squabbles to be resolved within the family circle. The second case involves 2 properties in the deceased estate. Now, an application is launched by T in the High Court seeking that the properties be restored to him as he holds power of attorney to act on behalf of his mother, Mrs. Masuku. So this matter is never ever finalized individually, but it is later consolidated with other matters in a settlement concluded in November 2021. Now, the third case is also launched by T. T asks the court to set aside the liquidation and distribution account, which details how Mr. Masuku's estate must be dealt with. And so in that application, he also seeks or asks that the court interdict or restrict the sale of any of the properties unless the beneficiaries to the estate all sign and give consent to such sale. Now, this matter is never finalized individually either, but it is later consolidated with other matters in a settlement that was concluded in November 2021. The fourth case is launched by a private company. Now, this company seeks to evict T and one of his sisters from one of the properties in the estate. The eviction order is granted by the learned judge S.A. Nkosi in the High Court. However, the company never follows up with an execution of that order, and so this matter actually is finalized individually, but it is nevertheless consolidated with the other matters in the, you guessed it, settlement agreement, which was concluded in November 2021. And then the fifth case is launched by T and three of his siblings, asking the court to remove their mother, Mrs. Masuku, as executor or executrix, if you like, of the deceased estate. Now, also contained in these proceedings is a prayer that the court should set aside, or in other words, should reverse the sale of one of the properties which has been sold at an amount of 700,000 emalangeni. Now, this matter is never finalized individually either, but it is later consolidated with other matters in the November 2021 settlement. Then the final case is effectively a consolidation of all the previous 5 cases. The parties hold hands, they conclude a settlement agreement, as you guessed it, in November 2021, bringing what looks like finality to the issues between them. However, in a matter of days, one of the siblings writes to T's attorneys asking for permission to send a qualified person to evaluate the family home so that when it is sold, this is done with correct pricing. T's attorneys respond to the request by saying that T is away in Johannesburg at the time, and so this sibling haggles with T's attorneys about suitable days to meet until T himself then writes a letter to the master of the High Court to make sure that no one dares wind up the estate until he and his mother have paid security in terms of Section 30 of the Administration of Estates Act. Now, this all happens in December, which is only very few days after the signing of the settlement agreement. The wheels then roll one more time, as Mrs. Masuku sees T's letter to the master as effective resistance to the settlement agreement, which, by the way, was made an order of court. So Mrs. Masuku then brings a fresh application in the High Court, basically to hold T in contempt of the court order, that being the settlement agreement. In that application, she also asks the court to evict him and any person holding under him from the family premises. Now, here's a sobering part of the facts. Mrs. Masuku's application is launched and is meant to be heard on an urgent basis by the learned judge M. Dlamini in the High Court. However, 6 days into the following month of January 2023, Mrs. Masuku unfortunately becomes deceased. Now, bear in mind that at her passing, she is still the executrix of her late husband's estate. Remember also that her husband passed away in the year 2001. So here comes the first question. What happens to the power of attorney once Mrs. Masuku dies? The Supreme Court provides an answer to this question, and it relies on authority penned by the learned author Robert Sharrock in a book entitled Business Transactions Law. The position confirmed there is that once a principal dies, the agency terminates. So Judge M. Dlamini nevertheless hears the urgent application and finds T in contempt. It then orders him to pay a fine of 100,000 emalangeni within 7 days or be imprisoned for 2 months. Then she makes an order evicting him and any person holding under him from the property. Finally, the learned judge orders T to pay costs of the litigation out of his own pocket and on a punitive or a high scale. So let's pause for a second here, because the Supreme Court had a mouthful to say about the learned judge M. Dlamini's order in the High Court. To be precise, they labeled the order as draconian, meaning excessively harsh or severe. Let's not go into the court's reasoning for this finding. Well, we know that the court reports that the learned judge allegedly then distanced herself from the order, as she said that it was different from the one she had in fact made. And then she recalled the matter to postpone it. And so the Supreme Court found that the High Court, and I quote, had no business correcting its own order once an appeal had been noted in the Supreme Court. For this position, the authority relied upon in the Supreme Court was the 2007 case of Nhlapo versus Howe, as well as the 2009 case of Evans versus Evans. Now, fellow writers, we could unpack the facts surrounding the High Court cases and the multiple appeals, but that would take up too much breath and too much time. So let us now dig into the most interesting legal questions considered by Eswatini's apex court in this case. The more important legal questions then answered by the Supreme Court are the following. 1. Can the High Court continue to hear a matter and issue orders where one of the parties has noted an appeal in the Supreme Court? The answer to this question is no. The Supreme Court's authority for this position is the 1977 judgment in the case of South Cape Corporation versus Engineering Management Consultants. You may refer to episode 1 to find out how this case was also interpreted there. And then the second question is, in the event that the High Court nevertheless proceeds to hear a matter and makes orders or rulings, does the aggrieved party then proceed under review in terms of section 148 sub 1 of the Constitution, or does the aggrieved party then proceed by way of an appeal? In order to answer this question, the court asked the Attorney General's office or the Attorney General to join in the matter, and then the benefit of the AG joining was to assist the court in drawing a distinction between the Supreme Court's appellate jurisdiction on the one hand and its supervisory jurisdiction on the other. Now, the AG's contribution to the case was an excerpt which comes from foreign law, namely a 2014 judgment from the Supreme Court in Ghana. That's right. This was the case of Republic versus High Court, Kumasi. What this case helped to clarify was the following. By ignoring 5 appeals, the High Court judge invited the supervisory jurisdiction of the Supreme Court. And then authority to buttress this position in the Eswatini court is found in the 2018 judgment of Eswatini's own Supreme Court, which was the case of Director of Public Prosecutions versus Sipho Shongwe, which essentially held that when any court seems or is alleged to be losing direction, it is the duty of the Supreme Court to intervene and bring order. The court went further and relied on the Sipho Shongwe case to entrench the principle that despite judicial independence, and I quote, so long as courts perform their functions in accordance with the law and the Constitution, they are masters of their own destiny. There is also no doubt that if a court of law strays outside the parameters of its jurisdiction, there has got to be some power or authority competent to rein order in that court. Now, in its initial findings, the court suspended any further winding up of the Masuku estate and interdicted any further litigation until the appeals had been heard and finalized in the Supreme Court. The court also ordered that because of the toxic relationship, and I stutter here because this is in fact the wording that the court used. Because of the toxic relationship developed in the High Court, a different judge would have to consider any other matters in future should they arise. And then finally, on the issue of costs, the court ruled that each litigant must bear their own costs, especially considering that the bond between them was that of family. Now, fellow riders, that brings us to the end of this episode. I would like to thank you for tuning into episode 2 of the Nkantolo podcast. Please do not leave this page without subscribing to our YouTube channel. It certainly helps us in a major way. Do give us a thumbs up, of course, if you found this episode to be particularly informative, and also hit the notification bell to see any of our future uploads. I would like to hear your views on this case, so please be sure to give us your thoughts in the comments section. And until next time, salut.